I, Manoj Kumar Chaudhary, Advocate, Supreme Court of India, welcome you all on behalf of Nani Palkiwala National Law Club. Today we have a Jayprakash Somani sir, founder and director of Nani Palkiwala National Law Club and a practicing advocate at Supreme Court of India and insolvency professional and independent director. Today our topic is case laws on bail matters. As we know, there are two types of bail and non-bailable offences. So if any person is accused in a non-bailable offences, either in IPC, NDPS, PMLA, or any specific laws like SC/ST Atrocity Act or Cyber Crimes in Information and Technology Act, then we have how to deal with the bail matters in a Supreme Court. So we have a 15 case laws related to that. Over to you, sir.
Thank you. Thank you, Manish. Friends, let's start our journey. 15 judgments of Supreme Court on bail matter in 20 minutes. So, first judgment, Bachchan Singh versus State of Punjab. Facts: the accused was convicted for murder and sentenced to death. He appealed for bail during the appeal process. Decision: the Supreme Court held that the death penalty should be an exception and under special circumstances, the accused may be granted bail. Ratio decidendi: bail can be granted if the accused shows that the appeal is likely to be succeed. Citation: AIR 1980 SC 898. Then second, Ram Singh versus Sonia and others. 2012. Facts: in a case of serious charges, the accused sought anticipatory bail. Decision: the court granted anticipatory bail due to the lack of evidence and undue harassment. Ratio decidendi: personal liberty is paramount and bail should be granted when there is no prima facie evidence of guilt. Citation: AIR 2012 SC 656. Case number 3, Mahipal versus State of NCT, Delhi, 2020. Facts: the accused faced charges under the NDPS Act, Narcotic Drugs Psychotropic Substances Act, and South bail. Decision: the Supreme Court granted bail, stressing the importance of the right to life and liberty. Ratio decidendi: the severity of charges does not warrant automatic denial of a bail. Citation: 2020 to SCC 118. Fourth, Niranjan Singh versus Prakash, 2008. Facts: bail was sought pending further investigation in a murder case. Decision: the court held that the nature of the charge is important, but shouldn't be the sole basis for denial of a bail. Even though serious charges are there, but that will not only ground to deny the bail. Ratio decidendi: the right to bail is not only focused on the crime's nature, but also on individual circumstances. Citation: 2009 to SCC 363. Case number 5, Siddharam Maitre versus State of Maharashtra, 2011. Facts: anticipatory bail was sought in a case of serious offences. Decision: the court laid down guidelines for the grant of anticipatory bail. So every lawyer should read this judgment carefully and read the guidelines to grant the anticipatory bail. Ratio decidendi, court must strike a balance between individual liberty and the interest of society. Citation 2011 1 SCC 694. Case number 6. Bail application of EJC Nabam Arabia 2016. Facts: a political figure sought bail in a corruption case. Decision: bail was granted, emphasizing that charges do not equate to guilt. Ratio decidendi, the prosecution must demonstrate an imminent danger for denial of a bail. Citation 2016 5 SCC 196. Case number 7. Pawan Kumar versus State of Haryana 2017. Facts: the petitioner was arrested under serious allegations. Decision: the Supreme Court granted bail focusing on constitutional right to liberty. Article 21, friends. Ratio decidendi, the presumption of innocence must be respected until proven guilty. Citation 2017 8 SCC 463. Case number 8. Ranjit Singh Brahmajit Singh Sharma versus State of Maharashtra 2005. Facts: the petitioner was charged under the Mocha and South bail. Decision: the court laid down factors to consider for a bail under special laws. So this is also important judgment for lawyer to read the factors to grant the bail in special law, under special law specific. Mocha is a special law of Maharashtra to control the terrorist activities. Ratio decidendi, the burden of proof lies with the state to justify denial of bail. Citation 2005 5 SCC 294. 9. Vijay Kumar versus State of Uttar Pradesh 2015. Facts: the appellant filed a bail application for a serious crime. Decision: bail was granted, stressing personal liberty. Ratio decidendi, each case must be judged on its own merit and facts. Citation 2015 7 SCC 196. Case number 10. Kalyan Chandra Sarkar versus Rajesh Rajan 2004. Facts: the accused sought bail in a case involving non-bailable offences. Decision: bail was granted, citing his role in the offences. Ratio decidendi, denial of bail requires solid justification from the prosecution. Citation 2004 7 SCC 528. Friends, I will give you the factors, 7 factors, 7 important points on which Supreme Court is granting the bail, on which point they are thinking and they are granting the bail. Okay. So I will tell at the end of this session, because I have to complete 15 judgment in 20 minutes first. So that is my commitment. Then I will tell you that 7 factors also, and I will tell you the sections of CRPC also and BNSS also related to bail matters. Case number 11, Babu Singh versus State of Uttar Pradesh, 1978. Facts: multiple accused sought bail for a crime with political motives. Decision: the court emphasized bail is a right unless opposed by a valid reason. Ratio decidendi, liberty must be prioritized unless strong evidence suggests otherwise. Citation: AIR 1978 SC 527. Case number 12. Maneka Gandhi versus Union of India, 1978. Facts: the case dealt with preventive detention and the right to a fair hearing. Decision: the court ruled against excessive deprivation of personal liberty. Ratio dissenting: personal liberty cannot be curtailed without due process. Very, very important. Citation: AIR 1978 SC 597. This video will be uploaded on YouTube channel, friends, shortly, and you will get the link in our official group, Nani Palkiwala 1 and Nani Palkiwala 2 groups. And then anytime you can watch this video again and again and memorize these case laws with citation and with facts, decision, everything. It's short, very short and sweet. And you will find my previous videos also on YouTube related to different laws, different factors. Next, I think Pooja, next our episode is on Custom Act. Custom Act. I will give you Custom Act's 15 judgments in 20 minutes. That is my favorite subject, Custom Act, because I am MBA in international business with LLB. Case number 13. Sushila Devi versus State of Uttar Pradesh, 2020. Facts: the accused was involved in a sensational case and South Bell. Decision: the court underlined the importance of ground for arrest. Ratio dissenting: denial of a bail must be consistent with fundamental rights. Citation: 2020 to SLR 446. Case number 14. Ram Ratan versus State of Uttar Pradesh, 2020. Facts: the petitioner contended for a bail in a heinous crime. Decision: the Supreme Court granted a bail, emphasizing individual circumstances. Ratio dissenting: each case specifies warrant for fair examination for bail. I'm once again reading this. Each case specifics warrant fair examination for a bail. Citation: 2020 for SCC 136. Case number last 15. Abdul Basit versus State of Uttar Pradesh, 2013. Facts: the appellant sought bail pending trial for a serious offense. Decision: the court granted bail, emphasizing judicial discretion. Ratio dissenting: judicial discretion should favor bail unless compelled reasons are presented. Citation: 2013 14 SCC 2203. Friends, I have given you all 15 judgments in which Supreme Court granted bail. So these judgments are very important for accused side lawyer, not for prosecution side lawyer. But prosecution side lawyer can take the lesson from this. Unless and until they are strongly opposing, bail cannot be denied, because personal liberty is related to that. And being a apex court lawyer, I am very happy to say that in our apex court, personal liberty and fundamental right is always taken care. There is, unless and until there are strong ground, they will not deny you the bail. But you have to find a good lawyer who will listen your grievance properly, who is not doing anxious, angry when you are calling. He is understanding your case, drafting well properly, timely follow-up. He is giving you date without asking him. Don't ask a date for lawyer. It is lawyer's duty to convey you the date. In my law firm, we are always conveying next date to the client. Client is not supposed to ask us date. But nowadays, due to online process, educated client are already have their date. They can regularly watching the Supreme Court websites like that. So when your lawyer is good, fair enough, cool-minded, understandable, giving a proper response when you are calling, lifting phone properly, then such type of lawyer is always a happy lawyer and he can give you the justice. There are so many lawyers in our Supreme Court Bar Association, Supreme Court Bar, AOR Association. There are so many lawyers. To any lawyer, you can give the case, but take the care and don't go walk in Supreme Court and search the lawyer there, because so many cheaters are there. Be aware from that. Be aware from that. Sometimes they are not lawyer, but they are cheating the people in the costume of the lawyer also. Sometimes that happens, and sometimes thoughts are wandering there. Okay, so take care about that. Now I am giving you the key aspects typically considered in a bail matter by the Supreme Court. Okay, 7 factors I am giving you. First, constitutional rights. The court evaluates whether pre-trial detention violates constitutional rights, including the right to liberty and fair trial. Point number 2, nature of offense. The seriousness of offense charged can significantly influence bail decision. For instance, more serious offenses, especially violence crimes or those involving large-scale drugs trafficking, may lead to striker bail conditions or even denial of the bail also. Point number 3, flight risk. Bhagne ka dar. The likelihood of the accused fleeing justice is a primary concern. The Supreme Court may examine previous conduct, ties to the community, and other factors indicating a risk of flight. Point number 4, public safety. Courts often consider whether releasing the accused poses a danger to the public or victim involved. This concern balances individual rights and against the safety of the community. Point number 5, judicial discretion. The Supreme Court may evaluate the extent of judicial discretion in granting bail and the standards that lower courts must follow. Bail reform. There have been discussions regarding the need for reform in a bail practices, especially concerning the vulnerable population who may be disproportionately affected by the bail system. And last, precedent and case laws. The court often relied on precedents and previous ruling that shapes the interpretation of bail laws. So friends, this is the from my side today. Just I am giving you sections, current sections of BNSS and also previous law CRPC. So bail was always granted under section 438 of CRPC. Okay. Discretion for granting of a bail to person apprehended to arrest. You can say it's anticipatory bail. 438 in CRPC, but 482 in BNSS. New law 482 section. And old law 438 section. And when you are doing appeal in High Court, then section 439 of CRPC, special power of High Court or Court of Session regarding bail. When trial court deny you bail, that time you have to approach Session Court or High Court for bail. So under section 439 of CRPC, you can apply for bail. And BNSS section is now 483. So now keep in mind 482 for anticipatory bail from trial court and 483 is for the bail from appeal from session court and high court. So this is from my side, friends, and very shortly I will organize a series of I think 4 or 5 maybe programs, episode series will be there for on English legal English, to improvement of our legal English. So we have taken efforts. One my enter have taken efforts. I have given her near about 12 to 16 different videos of Chief Justice of India, now retired, Dr. D.Y. Chandrachud's speeches, other Supreme Court judges' speeches, senior advocate speeches. I have given 12 to 15 different speeches, and I told her, you find the proper legal word for improving legal English. So she have made the list. That list will be around 600 words. But I told her, complete this to 100,000 words. Then she have done. I will publish its books also. But in this Nani Palkiwala series, we will take that program and gradually in each program we will complete 200 words. Okay, word, its meaning, and if possible, then we will give the sentence also. And when you are using that particular vocabulary in different sentences, in different circumstances, that time you can keep in mind that particular word. Only memorizing word or only reading of the legal vocabulary is not sufficient to improve our legal English. That's okay. Thank you. Thank you very much. Let's conclude. Manoj sir. Manoj will conclude this lecture. Just let me see. Your mic is, yes. Now you can unmute yourself, Manoj.
Thank you, sir. Thank you. It was a great session. Thank you, participants, for attending the webinar. And we have learned that 7 key factors that are important for making a ground for the bail. Thank you, everybody. Thank you once again to everybody. Thanks, sir.
Thank you. This episode may be a little bigger than 20 minutes, but I have covered that 15 judgment in 20 minutes. Okay. And latter part is the additional part. Okay. Thank you. Thank you very much.
Thank you.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और Flipkart पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।